Mr. Spearman.
Yes, may it please your lordships and my lordship. In this appeal, I appear for the appellant, Mr. Philip Ivey, together with my learned friend, Max Malin, Queen's Counsel, and the respondent, Genting Casinos UK Limited, represented by my learned friends, Mr. Christopher Plymouth, Queen's Counsel, and Mr. Syward Atkins. And the court will know that the central question on the appeal is whether the use of the practice of edge sorting amounts to cheating. And in a moment, I'm going to suggest that the issues on the appeal naturally break down into two parts. The first part involves determining the meaning of the word cheating for purposes of this appeal, and the second part involves the application of that concept to the facts of the case. But if the court will think it's helpful and appropriate, I thought I should just spend literally 2 or 3 minutes just saying a bit about edge sorting and the issues, not of course because the court won't appreciate those, but in case other people who are not familiar with the appeal don't understand what the issues are. So it's just a few sentences.
Very sensible. Thank you.
Thank you very much, my lord. What edge sorting involves is described in the first instance judgment of Mr. Justice Mitting in a passage that was adopted by the Court of Appeal and is replicated in paragraph 11 of the Statement of Facts and Issues. In essence, for purposes of the present case, it requires cards with a face value of 7, 8, or 9 to be turned through 180 degrees in comparison with all other cards. If that is done, and provided also that the following conditions are satisfied: 1, that the backs of the cards are not symmetrical; 2, that the same shoe of cards is used more than once; 3, that the cards, when reshuffled, are not rotated at all; and 4, that the leading edge of the first card in the shoe is visible to the player when it is sitting in the shoe and before the player places a bet. It is possible for the player to gain an advantage by looking at the leading edge of that card and assessing whether that card appears to be a 7, 8, or 9, and to place bets accordingly. On player to win if it appears to be a 7, 8, or 9, and on banker to win if it is not. And the reason why all that works, of course, is because what one is looking at is a situation where the shoe is a dispenser. It holds 8 packs of cards, the way the game was played at Crockfords, and at the front of the shoe is a small semicircular indent, which is used by the croupier or dealer to place pressure on the first card and pull it out. And because that horseshoe-shaped opening is there, and because in the case of the way this casino operated, it wasn't covered up as it is in many casinos with a brush or similar device, it was possible to see the leading edge of the first card before any card was pulled out. The court will know that the way the game is played is in rounds of cards, basically 4 cards called coups, in which the first card is always dealt to the player, the second card to the banker, the third card to the player, the fourth card to the banker. They're then turned over, and the object of the game is to get to a score nearest to 9, with 10s and above not counting as having any value. And then in certain prescribed circumstances, depending on what the two values of the hands are at that stage, either the player or the banker or both will get a third card. The court, I think, doesn't need to be bothered with the details of that, but there's a set pattern for that called the tableau, which dictates whether the player must take a third card or not, and whether the banker must get a third card or not. So the appellant used edge sorting when he played Punto Banco at Crockfords Club in London on the 20th and 21st of August 2012, and won the sum of £7.7 million, which he claims in this action. He contends that he's entitled to be paid his winnings because edge sorting is a legitimate advantage play technique. The respondent contends that the appellant is not entitled to succeed by reason of his use of edge sorting on 2 bases. The first is that the appellant thereby acted in breach of an implied term in the gaming contract between the parties that he would not cheat or otherwise act to defeat the essential premise of the game. And secondly, that the appellant thereby committed a criminal offence of cheating contrary to Section 42 of the Gambling Act 2005, and therefore he cannot succeed because his claim is founded on his own criminal act. And certainly the point of law of general public importance identified in the appellant's application for permission to appeal, and which I think led to the grant of permission to appeal, is the proper construction of Section 42. because as the court will know, what happened is one judge in the Court of Appeal, Lord Justice Tomlinson, followed Mr. Justice Mitting in deciding the case without reference to criminal law at all. The other two judges, Lady Justice Arden and Lady Justice Sharp, both decided the case in the Court of Appeal by reference to Section 42, but they took different views as to the requirement of dishonesty in Section 42. Lady Justice Arden finding there was no such requirement, and Lady Justice Sharp finding that there was. And of course, being a criminal statute, it was the gauche requirement of dishonesty, and whatever else is or is not clear in this case, that outcome in the Court of Appeal left the proper interpretation of Section 42 unclear and uncertain, and that's one matter which no doubt the court will be anxious to consider in the appeal. So with that very brief introduction, I'll turn, if I may, to the first part of the appeal, which is the meaning of the word cheating. Prior to this case, it has not been considered, that is the word cheat or cheating, in any case outside the criminal context. It certainly has been considered in that context, and our essential submission is that it is perfectly clear that in that context cheating requires dishonesty, and moreover we would say inevitably dishonesty in the gauche sense. But we go further, because we submit that when the court is considering the meaning of a word, it must be given its ordinary meaning unless the context shows that it's used in an unusual sense. If the context shows the word's used in an unusual sense, the court then will determine in other words what that meaning is. So whenever we submit you see the court using the word in a particular way, it is using it in the way which bears its ordinary meaning, unless you find some different indication. And the leading case, and in our submission perhaps the only case that the court needs to look at, is that of Scott and the Commissioner of Police of the Metropolis. Now, there are two versions of this in the bundle, and I apologise for this. One is in the original bundle B, and that has electronic page numbers, and of course I hope to be able to give the court those page numbers. However, after the bundle was compiled, it was noticed that that was not, in fact, a copy of the official report. It's the electronic version. And so there is a supplemental bundle C, which is not, I think, been electronically uploaded or made accessible, in which the reported version of the case appears. I have actually marked up the reported version in bundle C, but I hope I'll be able to work off the version in bundle B if that is what the court would prefer me to do.
We actually do have a supplemental authorities bundle C,
yes,
electronically.
Oh, you do?
Yeah.
Well, electronically, but not otherwise, I think.
But I'm not sure what the...
Yes, I've got it in both.
Well, I'm very grateful.
You'll probably find it in your bookcase.
I don't think I've got electronic page numbers for it. That's the trouble. But, not for C. I have for B, but not for C. Anyway, well, I'll do my best. So I will start with what this appeal was about. It was an appeal about the interpretation of the offence of conspiracy to defraud. And one of the arguments that was raised on the appeal was that you couldn't have a conspiracy to defraud unless the underlying acts involved a deceit. And that was the context in which the discussion about cheating arose. So I will give references as I can't give you the electronic references from the reported version. I'll give you the electronic.
Starts at 55.
Does it? Oh, well, sure. Oh, it's the same. I see. Oh, it's fine. In that case, it's easy. So I can go to C71 then.
Yes.
And you can see what the contentions were in front of the House of Lords in the case. They're at page 8.
It's always a pleasant surprise when the numbering on the paper bundle is the same as that on the electronic.
Well, it's more a surprise, my lord. It's a relief as far as I'm concerned, because otherwise I was slightly at sea. So I'm going straight to page C71, page 835 of the report, and you can see that there were 3 contentions advanced in front of the House of Lords. I should just say this, it doesn't matter. This was a case basically about conspiracy to defraud copyright owners. It involved, in the old days when films were played in cinemas with large reels and projectors, giving inducements to the projectionists to lend out the films overnight, where I think they were probably unlawfully copied, and then they returned to the cinema the next day for ordinary use, and the conspiracy, the gist of it was that people made money off that, and the copyright owners were deprived of the revenue they'd otherwise have got from the showing of the films in the cinema. So that's the context. And looking at D on page C71 or page 835 of the report, before the House, Mr. Blom-Cooper put forward three contentions, his main one being that she'd advanced unsuccessfully before the Court of Appeal and Judge Hines there could be no conspiracy to defraud without deceit. He further contended the Theft Act 1968 had abolished with effect from January the 1st, 1969, when the Act came into operation, the offence of conspiracy to defraud. He also contended a charge of the common law offence of conspiracy to defraud would not lie in respect to of a conspiracy to commit a summary offence created by statute. So I think it is the first one that one is looking at, the conspiracy to defraud without deceit. And one can see the conclusion at page C72, 836 of the report at H, after looking at some authorities. These citations suffice to show that conduct to be fraudulent need not to be deceitful. And then one can skip on to page C73, 837 of the report. Look, Viscount Dillon, who gave the leading speech, says this, between D and E, in the course of the argument, many cases were cited. It's not necessary to refer to all of them. Many were cases in which the conspiracy alleged was to defraud by deceit. Those cases do not establish there can only be a conspiracy to defraud if deceit is involved, and there are a number of cases where that was not the case. And I just want to refer the court to just two of them, I think.
Right.
The Crown against de Crom at the bottom of the page. The defendant was indicted for soliciting a servant to conspire to cheat and defraud his master by selling his master's goods at less than their proper price. Lord Coleridge, Chief Justice, said if the servant had sold the goods at less than their proper price, his employer would have been defrauded. The conviction was upheld. The conspiracy which the defendant was charged with incited did not involve any deceit of the employer. And then Quinn, defendants were convicted of conspiring to cheat and defraud the Great Northern Railway of Ireland of fares by abstracting return half tickets, selling them to members of the public. Again, there was no deceit of their employers. And then there's a reference to Wellham and the DPP and a speech of Lord Radcliffe's dealing with the expression intent to defraud. And again, I just read a little bit of that between E and F from Lord Radcliffe's speech. He said, secondly, popular speech does not give, and I do not think ever has given, any sure guide as the limits of what is meant by to defraud. It may mean to cheat someone, it may mean to practice a fraud upon someone, it may mean to deprive someone by deceit of something which is regarded as belonging to him or through, although not belonging to him, as due to him or his right. And he says at G, talking about Lord Radcliffe's speech, the passages which I cited from his speech are, I think, of general application. Then he discusses another case, the Crown against Sinclair 1968 case, which we also rely on in our case, where there was a conspiracy to cheat and defraud a company, its shareholders and the creditors, by fraudulently using its assets for purposes other than those of the company, by fraudulently concealing such use. Mr. Justice James, this is in the Court of Appeal, said at page 1250, to cheat and defraud is to act with deliberate dishonesty to the prejudice of another man's proprietary right. And then he discusses the meaning of defraud, and he says he doesn't have the temerity to give a comprehensive definition, but he says at C, to defraud ordinarily means, in my opinion, to deprive a person dishonestly of something which is his, or something to which he is or would or might be, but for the perpetration of the fraud, be entitled. And then lastly, he discusses at page C76 the common law offence of cheating, and he says this, between A and B, in East Pleas the Crown, Volume 2, the author stated in his view the common law offence of cheating consisted in the fraudulent to obtain the property of another by any deceitful, illegal practice or token short of felony, which affects or may affect the public. And then it's not, however, every species of fraud or dishonesty in transactions between individuals which is the subject matter of a criminal charge at common law, but in order to constitute it such, it must be such as affects the public, such as is public in its nature, calculated to defraud numbers to deceive the people in general. And Lord Diplock discusses the offences in short form in his speech, starting at the bottom of the page, C76, Withers, he says, established the following propositions. One, although at common law no clear distinction was originally drawn between conspiracies to cheat and conspiracies to defraud, these terms being frequently used in combination, by the early years of the 19th century, conspiracy to defraud had become a distinct species of criminal agreement, independent of the old common law substantive offence of cheating. The abolition of the substantive common law offence by Section 32(1)(a) of the Theft Act, except as regards offences relating to the public revenue, thus leaves surviving and intact the common law offence of conspiracy to defraud. And then he says where the intended victim is a private individual, the purpose of the conspirators must be to cause the victim economic loss by depriving him of some property or right, corporal or corporeal, to which he is or would be entitled. The intended means by which the purpose achieved must be dishonest. And then he says, talks about public persons, you don't have to, it's sufficient, 3, to cause them to act contrary to public duty, and the intended means of achieving this purpose are dishonest. So what we respectfully submit one gets out of that is, first of all, that cheating at common law inescapably involves dishonesty. And if the nature of the charge is one of conspiracy to do acts of cheating or acts of defrauding, that also must require dishonesty. That, I think, is now conceded by the respondent in paragraph 55 of their written case. A89.
Yeah.
So that's conceded. But more importantly, we say, or more generally, what one gets out of Scott is there's no suggestion that the word cheat was being discussed in any special sense. It was being discussed in its ordinary sense, its ordinary meaning. And what it means in a nutshell is it means to obtain property from someone or prejudice their commercial rights with deliberate dishonesty. That requirement applies just as much if the victim is a private person as if the victim is the public. So it's not just telling you what it means for purpose of the criminal law. We say it is telling you what it means generally. And we submit that's entirely unsurprising, because that is the ordinary meaning of the word according to the most authoritative dictionary of the English language, the Oxford English Dictionary. And we've obviously referred to that in our case, and it's at page E684 of the electronic bundle. One's got the Oxford English Dictionary of cheat at E684. The intransitive verb definition at 4 is to deal fraudulently and practice deceit. The definition at 2 is to defraud or to deprive of by deceit. And if one just glances, I'm not going to pretend to be comprehensive, but other words that are used in the dictionary on the right-hand page, page E685, cheater, you have got on the left-hand side, definition 2, a dishonest gamester, a sharper, said to be obsolete. 3, one who cheats or deals fraudulently, a deceiver, a swindler. And then cheating, one's got, in the second column on page E685, one's got fraud, deceit, swindling at B. So we say there's a consistent theme there, that cheating requires dishonesty. And that is certainly the position, we say, as far as the criminal law is concerned. When you get to the criminal law in section 42, when the Gambling Act was passed, what had happened by then was that all forms of cheating had been abolished by section 32 of the Theft Act 1968, except for cheating the revenue. And section 32 is at page E670 of the electronic bundle. This is the Theft Act 1968. Section 32(1), the following offences are hereby abolished for all purposes not related to offences committed before the commencement of this Act. That is to say, little a, very last line, except as regards offences relating to the public revenue, cheating. So all other offences were abolished. Of course, offences of conspiracy to cheat and defraud were not abolished. That's the very point that was decided by the House of Lords in Scott, but they plainly involved dishonesty, as I've just shown you in Scott. And the only other offence that was extant that related to cheating was the Section Theft Act offence of going equipped to cheat. And I hope that is in the bundle in the right place, because there have been some problems with this as well. I think it may be in bundle C. We cited it in our case, but of course, give me a moment. I think the relevant section is in C at page...
About 89 or 90.
I'm so grateful, 89 and following. So there's the offence of going equipped for stealing and so forth at C92. A person shall be guilty of an offence if, when not at his place of abode, he has with him any article for use in the course of, in connection with any burglary, theft or cheat. 25.5 on the same page, C92, says that cheat means an offence under section 15 of the Act, and section 15 back at C90 deals with obtaining property by deception. A person who by any deception dishonestly obtains property belonging to another with the intention of permanently depriving the other of it shall, on conviction or indictment, be liable to imprison for a term not exceeding 10 years. So you've got three forms in which cheating was still recognised by the criminal law when the Gambling Act 2005 was enacted. You've got the cheating the revenue common law offence, which survives section 32. You've got the going equipped to cheat offence, which was then extant in the Theft Act from section 25 and section 15 read together, and you've got conspiracy to cheat and defraud, all of which absolutely inescapably involved dishonesty. So what one would expect when you come to see a new piece of legislation which is dealing with an offence of cheating is that unless very clear words indeed were used, cheating would be used in the same sense when you look at that piece of legislation. And there is nothing whatsoever in section 42 to suggest any contrary interpretation.
Yeah.
So, gratefully all should say yes, that's where we got up to anyway. That's section 42. We put our submissions on the construction of section 42 in our case. The court will obviously have had plenty of opportunity to look at that. It's at pages 646 in the electronic bundle. 646 to 647, the electronic bundle, says this: a person commits an offence if he, A, cheats at gambling. I think we didn't bother about the accessory bit, which is B. Then we've got little 3. I'll say 2, for the purpose of subsection 1, it's immaterial whether the person cheats, improves his chance of winning anything or wins anything. And then you've got at 3, the section that has troubled the court, below, without prejudice to the generality of subsection 1, cheating at gambling may in particular consist of actual or attempted deception or interference in connection with the process by which gambling is conducted, or, for present purposes, a game. So that's the position. And there is no suggestion whatsoever that cheating is used in some unusual or different form than the forms I've shown you. It's perfectly clear in our submission that subsection 3 is not a deeming provision. It's not saying any actual or attempted deception or interference in connection with a game and so forth will be cheating. What it is saying is that it is one way in which cheating may occur is by actual or attempted deception or interference in connection with a game, but we submit it's always got to have the character of cheating to make it a criminal offence. And obviously, as a criminal statute, it must be construed strictly. And the logic, the natural construction, the construction which accords with the existing criminal offences that coexisting at the time that it was enacted, and a restrictive interpretation which is appropriate all suggest that the forms of deception or interference must be dishonest. And that's really, dare I say it, the long and the short of it. Now, stand back and take a break. Our theme is that it's all very straightforward because cheating is an ordinary word. It's used in different contexts, but it always has the same meaning. It's never been departed from. But I'd just like to point out, as the court will no doubt notice, really the respondent has got three different meanings of cheating, or at least three. The first one is they accept that for purposes of criminal law, apart from Section 42, cheating requires dishonesty. And I think they must accept that it requires dishonesty in the gauche sense, because it's a criminal regime. They then got a second meaning, which is that in Section 42, it just means any interference or deception, i.e., anything at all that interferes with or involves a deception in connection with a game. Nothing to do with dishonesty and nothing, I'd like to say, to do with unfairness. They just say any interference or deception. So it would mean, in our submission, that somebody who disrupts a game because they're at their wits' end with losing and feels despair and just throws everything over, somebody who comes in to stop a family member from carrying on gambling because they're losing all the family money and disrupts the game, somebody who intervenes as an anti-gambling protester and interferes with the game will all be labelled cheats. And in the context of an example given by the judge at first instance, although obviously didn't relate to a game, related to a race, when Emily Dickinson threw herself in front of the horses in the Derby as a political protest and disrupted the race, she would be regarded as a cheat if this section applied to races as opposed to games. So that we submit just simply can't be right and is very extra. And it's very odd because it's a definition or interpretation on their construction which goes further than their civil law definition, because they've got a third definition. They say the criminal law one mostly is dishonesty. The criminal law one, Section 42, is basically almost strict liability. As long as the act is intentional interference, intentional deception, it's a criminal offence. And then they have a civil concept, they say, which is basically a different dictionary definition, which is not just dishonest, but also unfair. So their civil meaning is somewhere in the middle. It's not as bad as dishonesty, but it isn't just intentional. It's got to be unfair as well as intentional. So really the battle lines between us are in our submission, fairly straightforward. We say that it's perfectly clear that it has always meant, does mean and always has meant to act fraudulently, practice deceit, and so forth. And we would respectfully suggest that if you even try to inject the concept of fairness into Section 42, or indeed into the notion of the implied term, you reach an impossible position, because it's a totally vague and subjective concept. What is fair in this context? There are many contexts where it's possible for the court to have an idea of what's fair, procedural fairness, and so forth. But it's very difficult to define what is fair and unfair in this context. And I was thinking, actually walking here this morning, probably a too banal and humble example, but those of us who've ever had to adjudicate on disagreements between children who complain about what's fair and unfair and deciding whether what's fair and not. It's a fairly humble example, but the answer is it's not easy to do. And obviously from one person's perception, something may be very unfair, another person's perception, it's totally fair. And you get into a lot of boundaries, certainly in most sports, and I suggest in many card games, if you started defining cheating by a criterion of fairness. In the criminal context, if you're looking at it in that context, this isn't the respondent's case. The respondent's case is not that cheating in this context of Section 42 is not just dishonest, it also extends to unfairness. There are cases it extends to any interference or deception, but if you injected the middle ground of fairness in there, that again we'd say would be totally unacceptable, because that's a very low level of moral culpability, just acting unfairly, and to condemn someone to exposure to imprisonment for up to 2 years for being unfair is most unlikely to be what Parliament intended and not what Parliament intended. And really, the whole concept we submit just takes you back to a subjective nature, which is really a question of social convention about fairness in playing games. And so that is that. We would especially submit that the concept of deception in section 42 does connote dishonesty. And indeed, Lord Lane, if I may just refer you to it briefly, in Gauche, gave that as a classic example of dishonesty. This is in the electronic bundle, page C49, Gauche in the Court of Appeal, 1982, at page 1060 of the report, where he's saying at G, the difficulty with section 15 of the Theft Act 1968 is that dishonesty comes in twice. If a person knows he's not telling the truth, he's guilty of dishonesty. Indeed, deliberate deception is one of the two most obvious forms of dishonesty. And we respectfully submit that that's absolutely right. We would say there's a lot of difficulty in coming up with a concept of honest deception, a concept which Lord Justice Tomlinson seemed to think existed. But if there is such a concept, and you're faced with a choice in a criminal statute of criminalising only dishonest deception, or if there is something different, honest deception as well, then applying a strict construction to section 42 means that the honest species of deception cannot have been intended here. And once you have got to the stage of accepting, as we say, it's inevitable that the deception element is dishonest, to then say, well, the interference element doesn't have to be dishonest is a nonsense, because you've got two instances of how an offence may be committed, one of which requires dishonesty and one of which doesn't. So for a clutch of reasons, we say with respect the section 42 point is really quite a short point. It's as plain as a pikestaff that it requires dishonesty. But wider than that, we say it does so because it is simply manifesting a criminal sanction for an ordinary activity that has an ordinary everyday meaning, the activity of cheating, not because it's creating some unique or different concept of cheating and then criminalising that. It's just using cheating in the ordinary way. And the court will have seen that that is supported, I can take you to it if you want, but it's in the case supported by the explanatory notes to the section, which we say is a fairly reasonable guide. I don't know if the court wants me to go to that. You've seen the point in the case.
Perhaps you could just give us the...
I feared you might say that.
the
The reference, yes, all right. There's two places I think it comes into the notes. They may be just manifested as the same thing. One of them is in the Hansard materials, and one's in the guidance notes. So I'll just find the guidance notes, my lord.
Well, take your time. Do that later.
No, it won't be. I think it's 620 of the electronic bundle.
Yes.
These are the explanatory notes to the section. It may be worth, actually, I shouldn't rush, it may be worth spending a moment on it. 163, the paragraph says this: the word cheating is not defined but has its normal everyday meaning. It's committed both by cheating directly or by doing something for the purpose of assisting or enabling another person to cheat. Someone does something inadvertently, therefore doesn't commit an offence. And subsection 3, I'm reading now from 164, skipping over 2, provides that in particular cheating may include actions that involve actual or attempted deception or interference with the process involved in the conduct of gambling or with any other game, race or other event or process which gambling relates. Subsection 3 does not provide an exhaustive definition of cheating. It's made expressly without prejudice to general meaning. And interesting enough, the words used in the notes are the words may include, the word in the actual legislation is may in particular consist of, and the respondent places a lot of reliance on the use of the words may in particular consist of, but we respectfully submit that they don't make any difference in meaning at all, that they are used as meaning includes. And as far as the Hansard extracts are concerned, that they'll be round about page E689, they're to very similar effect, perhaps the same effect. At this time, the section was, I think, section 39, clause 39. So if you go to page 694, I'm so sorry.
694.
694, E694.
Thank you.
I think it's exactly the same wording, and it may well be explanatory notes, just copy this. The word cheating is page 1, paragraph 138. It's not defined, but has its normal everyday meaning, and then 139, paragraph 139, subsection 3 provides in particular cheating may include, etc. So it's the same wording. I dare say explanatory notes just taken directly from that. But those are the Hansard.
But those are the explanatory notes to the bill, are they?
They are, yes, my lord, yes. And obviously they're not, they plainly don't determine the interpretation, but we say they're a pretty good guide, and we also say they happen to be right. That is that. Now, I don't know if there's anything else that the court would like me to say about 42. I think that's perhaps all I had to say.
Thank you.
That means no.
It does.
Very well.
Silence means...
Yes. So the question the court may be saying is, well, that's all very fine, but that's an answer to one of the, if I'm right, an answer to one of the grounds of defence against my client's claim, the ground that my client is founding his claim on his own unlawful act, because the dishonesty, as I've said more than once, for this purpose has got to be gauche dishonesty, and if nothing else is clear, it is clear that the judge found that Mr. Ivey regarded what he did as honest. He did not regard it as dishonest, and he accepted his evidence on that. And so that, in my submission, would be the end of it.
Well, it wouldn't actually be the end of it, would it, even on Gosh? It's not a question of whether he regarded it as legitimate or honest. It's a question of if you adopt the two-stage direction which Gosh enjoins, it's not a question of his subjective view of his behaviour. It's a question of his view of other people's thinking about his behaviour.
Well, it's a question. Of course, your lordship is right. The two-stage test is what was done dishonest by the standards of ordinary honest people, and does he realise it? Well, I'll be more careful in my use of language. There is no finding at all in the judgment below that Mr. Ivey was dishonest in any sense. There's no finding of that at all. He was found to be an honest witness, someone who personally didn't believe that what he was doing was dishonest. And the judge made no finding of dishonesty at all. That's what I submit is if you look at the judgment, is clear. And he kept well clear of dishonesty. He knew, obviously, about the Gauche test. He knew about the Starglade properties and Nash formulation. I had them well in mind, but what he did, and this isn't I'm not accusing him of coming up with some formulation that was craftily designed to get round my client's case, which I think the respondent's case suggests I'm doing. I'm not suggesting that. What I'm saying is that if the judge considered that Mr. Ivey was dishonest in any shape or form, that there's no reason why he would have hesitated to say that, because one of the debates in front of him was whether cheating required dishonesty. And if he thought Mr. Ivey was dishonest, it would have been very simple for him to say, well, that's a very interesting debate, but I consider he was dishonest, so we didn't really get into it. But the one thing that is absolutely clear is the judge did not do that. What he did, when he formulated his claim of cheating, he formulated a series of propositions that a request was made, the effect of which was known to the person making the request, the effect of which wasn't known to the person receiving the request. If the recipient of the request had known what its significance was, they wouldn't have complied. If you do that, that adds up to cheating. That's what he did.
But why is it helpful to, as it were, do it as a two-stage process that then involves considering the meaning of the word dishonesty? Isn't it more appropriate and less likely to lead to error if you say the word is cheating, these are the facts? Was that cheating?
Yes.
Why take a detour into dishonesty?
Because it isn't so much a detour in my expression. If one party is asserting that what cheating requires dishonesty, and the judge is the view that it does require dishonesty.
No, I understand that. All I'm saying is, why take that route? Why not just say the word is cheating, these are the facts? Is it cheating?
Yes.
Well, that's what the judge did, isn't it?
Yes, exactly.
Look at 49.
It is, but what's wrong? It seems to me it's more likely to lead to mistakes if you, as it were, redefine the word and then ask if your redefinition is satisfied.
Well, I would invite the court to look at it slightly differently and say that the proper starting point is to ask yourself and answer the question, what is cheating, and then ask whether what happened here fits in with that definition, because it's jumping the first step completely to just say, well, this is what happened and I think it's cheating, without any explanation as to why. I mean, you're quite right, the judge did what he did, but
Applied an objective test to cheating.
yes.
Well, what's wrong with that?
Well, because it involves because in my submission it involves
Well,
dishonesty.
you're going to come eventually, but you've been talking to us so far about the criminal test,
Yes.
dishonesty. You're only too alive to the fact that there's a different test in the civil court, and you're presumably going to come eventually to why that doesn't apply in a case where there's a civil action brought by Mr. Ivey against the casino.
Yes. Well, the answer
You're
is...
coming to that, I'm sure.
I'll come to it now, my lord. I'm prepared to attempt to rise to the challenge. The reason in my submission is for the reason given by Lord Millett in Twin Sectra, in his speech, which I'll find the electronic bundle reference, starts at page E552. We say this is right, and moreover, we say it has applied in other cases, and it's page numbers are E584 and E585, and this is Lord Millett's discussion in Twin Sectra of dishonesty as a state of mind or as a course of conduct, and gauche. And before I do this, of course, I'm well aware that number one, Lord Millett's speech was a minority speech.
You can't stop at Twin Sectra, can you?
No.
I'm not seeking to do that, and I will come on to that.
Slightly dangerous point of departure.
Well,
Either you've got the majority view, which many might say is somewhat questionable now in light of Barlow Clowes and other cases, or you've got the minority view, which has the disadvantage of being a minority.
well,
Maybe that many people would say that although it hasn't actually been said that the minority view is right, it may be better to look at the cases which superseded.
before I do what I'm about to do, which is to read these paragraphs, can I again try and rise to the challenge of that? Lord Millett, if I may put it this way, was you might call him a purist or a hardliner on this. He was the one who actually was most vehement that the combined test should not be imported into civil law.
Right. That's right.
And I'm not shying from this because I'm delighted to discuss the topic. It's a very interesting topic, but what has happened since. But he was the one who said, essentially, dishonesty as state of mind is relevant in crime and course of conduct is relevant in the civil law. But he is the one, as I'm about to show you, who said there is an exception to that, where the nature of the charge in the civil case depends upon a dishonest state of mind. But to put it in context, I'll just read it over so we're not confused about what Lord Millett was saying. At 115, in gauche, Lord Lane drew a distinction between dishonesty as a state of mind and dishonesty as a course of conduct, and held that dishonesty in Section 1 of the Theft Act 1968 referred to dishonesty as a state of mind. The question was not whether the accused had in fact acted dishonesty, but whether he was aware he was acting dishonesty. The jury must first of all decide whether the conduct of the accused was dishonest according to the ordinary standards of reasonable, honest people. That was an objective test. If he was not dishonest by those standards, that was an end of the matter and the prosecution failed. If it was dishonest by those standards, the jury had secondly to consider whether the accused was aware that what he was doing was dishonest by those standards. That was a subjective test. Given his actual subjective knowledge, the accused must have fallen below ordinary objective standards of honesty and subjectively have been aware that he was doing so. The same test of dishonesty is applicable in civil cases where, for example, liability depends upon intent to defraud, for this connotes a dishonest state of mind. And then he cites, this is a decision of the Court of Appeal of Hong Kong in which Lord Hoffman gave the leading judgment. It isn't in the bundle. I can tell you about it. I've looked at it. I didn't think it was added anything to Lord Millett's distillation. Was a case of this kind, trading with intent to defraud creditors. But it's not generally an appropriate condition of civil liability, which does not ordinarily require a guilty mind. Civil liability is usually predicated on the defendant's conduct rather than his state of mind. It results from his negligent or unreasonable behaviour, or where that is not sufficient, from intentional wrongdoing. And so the answer that I give to my Lord Hughes is that, in fact, in my respectful submission, the twin sector and Yardley test, as interpreted, clarified, metamorphosed, whatever you wish to say, by later decisions, Barlow, Clowes and Abacha and Starblade and so forth, is not, in my submission, a test of universal application in all civil contexts. And
Have you given us Barlow, Clowes and Abacha or not?
No, because
Right.
but I'm, of course, delighted to do so. But they're discussed in Starglade, and I think probably the court is very, very familiar with what they do. I mean, I hope I've got this right. In very simple terms, although twin sector was dealing with civil liability, the majority speeches, on one reading at least, proposed a combined test which was, for all practical purposes, the same as the Gauche test. Subsequently, in the Privy Council case of Barlow Clowes, Lord Hoffman and I think Lord Hutton clarified what they'd said. Certainly Lord Hoffman had said in twin sector and said that wasn't really what was intended. Right. And then there have been other cases of which Abacha is one and Starblade, I think, is the end of the line that we've put in front of your lordships, in which the court has said, well, that is right, and we can now proceed on the basis that what people at one time thought was the ruling of the House of Lords in twin sector, in fact, is not that ruling. It is the ruling as now interpreted by Barlow, the Privy Council in Barlow, Clowes and Abacha. And so one has got an objective test. But the point I make is it is not a universal objective test, and no one's ever actually presented it as such. It's quite important in my submission to bear in mind where all this came from. What one is looking at as a starting point with accessory liability for breach of trust. And the crucial thing that happened in Royal, Brunei, Alliance and Tan, essentially, was that Lord Nichols moved the dishonesty criteria from that of the trustee under Barnes and Addy. It had to be a dishonest breach by the trustee in which the accessory assisted, from the trustee to the accessory, and said it had to be a breach of trust in which the assistance of the accessory was a dishonest assistance. That's the crucial move that was produced by Royal, Brunei and Tan, but it applies in cases of constructive trust, where the court is looking at a course of conduct by an accessory, and it's saying, well, we are treating that as dishonest. It does not apply in my submission where you're, for example, dismissing an employee on grounds of dishonesty. For example, if that's what you're doing, I would say you don't apply that test. You have to look at whether they thought what they were doing was dishonest. I mean, one's got hundreds of examples, probably all bad, but if the employee takes some money because he needs money to get home out of the till, and he's going to put it back the next morning, and he thinks that's honest because he needs to get home and there's no one around to ask, and so on. I would say you look at his state of mind. You don't just look at, say, well, objectively, is that up to some objective standard? That would be my submission. It'd be very odd if you did, because dishonesty as a starting point is actually a subjective notion. I know the law has developed a course of conduct and objective criteria, but as a starting point, it is a subjective matter. And I think Lord Newberg was saying to me a minute ago about the two-stage test, or he was saying in a different context about why do it in two stages in my submission about Mr. Justice Mitting? Why not roll it up into one? I mean, one of the problems about gauche, at least identified by academic writers, is the problem about the two-stage test. And I mean, I'm again very delighted to talk about this, but I mean, I'm not sure it's rising as appeal. I mean, the difficulty, probably, just trying not to be abstruse about this and refined, just thinking about juries, is they're asked to consider, first of all, what is the standard of ordinary reasonable people or honest people, and then ask whether, if the defendant asserts he didn't think he was being dishonest and they believe that, was he, is it credible that he thought that was compliant with the ordinary standards? One of the difficulties is that it's not clear really how juries either do apply that or expected to apply it, because one problem is probably that most people, when asked to, as ordinary citizens, are asked to answer whether something complies with ordinary standards, will ultimately apply their own standards. Most of them will. I mean, most of them won't say, well, I'd have done the same, but I'm dishonest, so I should exclude that. And in other areas where you have, used to have anyway, in libel, for example, you had concepts of the ordinary, reasonable, fair-minded reader and so forth, there are guidelines to help people as to what is meant by that. And I will obviously know about them, but these days it's all done by judges. But the approach is you look for someone who is a typical publishee of the publication, who's reading it once, who's not avid for scandal, who reads in implications more readily than the lawyer would, and so forth, a whole load of things. How juries in the real world apply all that may be more problematic, but at least they have some clues as to what to do. But the problem with the criminal cases is you get, obviously, in the nature of the jury system, you get a mix of all sorts of people from different walks of life, and you get perhaps different perceptions of where the boundaries are between what is ordinary, honest behaviour and what isn't. The one difficulty, perhaps, is the example given in Gauche of the person from a foreign country who arrived in this country and gets on a bus and gets off without paying because they don't understand that there's any need to pay because public transport's free in their home country. The court breaks that down into two things, saying, well, that's obviously dishonest to start with, but...
I've never understood that.
No, well, that's what I'm saying, my lord.
Why on earth should anybody think that anybody who genuinely believes that public transport is free is acting dishonestly if he gets on the bus without paying?
Exactly. So what you're...
Never a remotely useful analogy.
No, my lord, maybe not, but it's the one used by the court, and it's the one that possibly illustrates the, if not the fallacy, the difficulty of the Gauche approach.
It does indeed.
Because the real question probably is a sort of rolled up question, which is the jury, I know what a criminal case here, the jury should be told, well, these are the circumstances, this is the state of mind of the person, his state of knowledge, this is what happened. Do you...
State of knowledge, do you say it was dishonest or not?
No.
Precisely.
Well, I'm grateful your lordship was kind enough to agree with that, but what that means is there really isn't...
If that's right, why can't the judge do precisely what he did in 49? And in any event, why should the Gauche two-stage test apply to a civil action in which someone is trying to recover his 7 million?
It's not so much that, it's more to do with the fact that what, if you reformulate Gauche in what arguably would be a more logical and coherent fashion, what you're recognising in my submission is that in all these examinations of the issue of dishonesty, there is an intense subjective element. It's a sort of all the circumstances of the case element, which involves the...
No, there isn't a subjective element in that. There is, except to the extent that you ask what the defendant knew.
Yes.
Not what his opinion was of the standard of his conduct.
No, you certainly don't do that, but you ask whether...
So you ask if he knew, for example, that people were expected to pay on the bus.
Yes.
But that's quite different from asking whether he thinks that people ought to pay on the bus.
No, he wouldn't. Well, if you
Isn't it?
Well, I don't know if you, it's a difficult debate. If you start telling him,
Okay.
well, okay, you don't think that, but does it change your answer if you know that everybody else pays on the bus? He'd probably say, well, it does change my answer, because although I didn't think you had to pay, well, if everyone else does it, I can see
There must be a rule.
there must be a rule. So I don't, with great respect to your lordship, I don't think it's really as easy as that. What I would say is if you do it, I'm not saying fairly, a different way, what you really come back to is a recognition of a subjective element. And in fact, in all these speeches, including Lord Nicholls' speech in Royal Brewing Irons and Tan, there's a recognition of the subjective nature of tests of dishonesty. And I'm well aware he ultimately came up with what he said was an objective standard. But you're certainly looking at states of knowledge. That's got to be right in my submission. You must be able to look at that. You don't just look at the conduct alone. You must look at knowledge. Yep. And yes, you can divide knowledge and belief, I suppose. But I think once you get to a stage where, in my ken, this is all right, I don't see what's wrong with it. As far as I could see from the nature of interaction, I thought it was all right. You're getting very close to his belief. I mean,
No, I follow what you say.
so
Thank you.
I mean, that's the reality. And of course, in the real world, in the Crown Court, the Gauche test really is not applicable in very many cases. There's guidance about it, because most cases are cases where the act is one of obvious dishonesty, and the real issue is, did the defendant perpetrate the act, like pickpocketing or something of that sort. It's not whether he believed that it was part of the acceptable standards of ordinary people to do that. It's really to do with that. So it's not a test that perhaps comes into play, at least shouldn't come into play on a daily basis very much. But I hope, entirely respectfully, demur from the proposition that because twin sector, as clarified in later cases, has come up with a test for dishonesty in civil cases, it applies in all civil cases across the board. And I know Lord Newburgh wasn't very impressed by me citing Lord Millet, but I say that's what he was envisaging, and he was right to do so. As I say, he was clear about the basic demarcation lines between civil and criminal law in this context. I mean, in fact, just to put a footnote on this, I mean, the trouble is really the whole question of dishonesty as a state of mind or as a course of conduct is possibly the wrong question. I mean, that goes back to Gauche. If you ask the wrong question, you end up possibly with the wrong answer. It's not really, because that separates out state of mind, going back to my Lord Hughes question, is partly about knowledge as well as belief. So if you start, I won't say any more. I've said enough probably. It's at least arguably not the right question. So what I am submitting is that cheating does require dishonesty, and it requires dishonesty in a subjective sense. It's a serious wrong, as Lady Justice Sharp recognised, to say someone's a cheat, and it requires that level of dishonesty, and that is subjective dishonesty. And that's what, if you look at it in terms of implied term language, what do the parties to be taken to have meant and agreed when they agreed that Mr. Ivey would not cheat, that they would be taken to have meant and agreed that he would not cheat in the sense of cheating in its ordinary everyday meaning, which in my submission, as I've hoped to demonstrate, means behave dishonestly. That's what it means. Obviously, if the court says no, cheating means something different, like fairness, for example, then you can apply a different criteria. But I say that the correct criterion is one of dishonesty. And there's certainly no case law that has been put before you, other than perhaps this case at lower levels, which suggests that the courts have ever looked at cheating as being involving some lesser mental element. So that's the basis on which I say that this is relevant. If you're not going to accept that dishonesty is a requirement of cheating, then you have to ask, well, what else? What else is there? And one of the respondents' answer is, well, fairness is there, and they submit that's what runs right through the judgments, although nobody ever used the word fair, except for Lord Justice Tomlinson, and he didn't decide the case on that basis. And I'd just like to show the court, if I may, really how this case has been run, just looking at the way it was pleaded to start with. And this is in the defence, is in Bundle A. Electronically, it starts at A209. And the relevant bit is in the summary of the defence at A211. 9 rehearses that the claimant attended the club and purported to win £7.7 million. 10 says the defendant isn't liable, and then it says why. And 11 says baccarat is essentially a game of chance in which the player must bet upon the relative value of a hand of cards in a pair of hands called a coup for its dealt and revealed. The claimant, in conjunction with an associate, believed to be Miss Chun Sung, we've called her Miss Sun, her real name might be the first bit, I don't know, we've called her Miss Sun, operated a scam by which they were able to identify the likely value of the first card in each coup, for it was dealt and revealed, and that's defined as the scam. The scam thus deprived the game of its essential character. It was also cheating for the purposes of Section 42 of the Gambling Act and amounted to a fraud at common law. Accordingly, as the scam deprived the game of its essential character, no game was in fact played in relation to which a gambling contract could have arisen. Even insofar as any such contract did arise, it contained an implied term the claimant wouldn't cheat or otherwise act to defeat the essential premise of the game, and if he did so, the contract would become void. And then third, the claim is in any event based upon the illegal acts of the claimant. And then one's got the scam at A213 onwards, and you've got, I won't read all this unless people want me to, you've got the citation, the one way of obtaining first card advantage is to dupe the dealer into sorting the cards, so the value of the first card, each coup becomes apparent to the player. And then in 23, it was the second variety, that's the duping of the dealer variety, and then they say towards the end of 23, in this manner they instructed the dealer unwittingly to sort the cards, defendant staff saw nothing suspicious and so forth, and then you've got the 3 defences at A215. First defence, the premise of the game, I'm reading the third sentence in 31, is thus defeated. The player already knows what the first card in the coup is likely to be before he places his bet, and the cards are dealt with and turned over. Pairs and perverts the element of chance, the essence of the game. That's no game. Second defence, contract became void. Claimant would not cheat or otherwise act to defeat the essential premise of the game. We say that last bit, defeat the essential premise, is basically just a repetition of the first ground. There was a defeating of the essential premise. By the scam, the claimant cheated at the game and or acted to defeat its essential premise. And then you've got Section 42 on the third defence, which is the criminal, based on illegality. So the claim was run basically as, in summary, a scam, a fraudulent misrepresentation. That's the sort of gist of it. Mr. Justice Mitting, in my submission, nowhere says anything about unfairness. He never uses that word. I know the Lord Hughes may say, well, you can put that label on what he found, but he certainly never found that. He wasn't addressing, I don't think, a plea that Mr. Ivey behaved unfairly, because that, in my submission, is quite a different concept from cheating. Unfairness is a concept which is recognised in law and appears in many concepts, but that wasn't really the way the case was run. So the judge, if we can look at page A199 of the electronic bundle, paragraph 33, he broke the defence is up into three,
Yes.
denies liability on three related grounds. No game of Punto Banco was in fact played because the premise on which the game proceeds, the cards be dealt at random, was defeated because the player knew what the first card was likely to be. So he put the defeating the essential premise of the game all into ground one. Then two, implied term of the claimant wouldn't cheat, and that term was broken, and then the criminal offence. And then he rejected the first ground at 34. Don't accept what was played was not Punto Banco, game played was the rules, card dealt in a prescribed sequence, and so forth. All that happened was by reason of the advantage game, where the claimant acknowledged that the first card to be dealt was or was not a 7, 8, or 9, the odds had changed and now favoured him. Even if it amounts to cheating, he was still playing. So that's the first ground. That's the judge rejected that, and that hasn't been appealed against. And then he said it turns on the second and third grounds at 35, and as we know, he went on to decide the case on the second ground and never dealt with the third ground because he didn't consider that it arose. And it's quite important in my submission when one's looking at how he dealt with the second ground at 50 of the judgment, page A202. It wasn't limited to what Mr. Ivey genuinely believed. There was plainly other material in front of the judge because he says that at 50, the fact that he's genuinely convinced he's not a cheat, and even that opinion commands considerable support from others, see, for example, Dr. Jacobson. So it's not just Mr. Ivey's idiosyncratic views, and the judge referred to the expert evidence that he'd had earlier in the judgment, and it's page A199 onto A200, and both sides called experts. So perhaps I can pick it up with the court's permission from paragraph 36 of the judgment. He ends 35 by saying there is therefore no case law on what amounts to cheating. And then 36, he says, Section 18 was repealed by Part 17 of the Gambling Act 2005 with effect on the 1st September 2007. That's the previous legislation. This is, as far as I know, the first case in which the question whether or not the conduct of a party to a gaming contract amounted to cheating has had to be determined in an English court. There is no commonly accepted view amongst those who play Punto Banco about whether edge sorting does or does not amount to cheating. David Mills, a level-headed and experienced English expert in casino gambling, considers that it does. Towards the end of 2003, he conducted a survey amongst 7 of the 8 biggest casino operators in the UK. He found that 4 out of the 7 considered it was cheating, 2 out of the 7 considered it was not a legitimate practice, which I had in brackets. They did not consider it was cheating, but it was not legitimate. And the remaining 1 considered it was not cheating nor illegitimate. So even amongst the 7 big casino operators, you do not have unanimity. You've got 1 out of 7 thinking it isn't cheating at all, and 2 out of them think it isn't cheating, but it's some other illegitimate activity. And you've got a majority, 4 out of 7, the smallest majority you could get on that number, saying it is cheating. And then you've got the rival evidence. Dr. Jacobson, to whom I've already referred, who has extensive experience in the USA of casino gambling, both as a consultant to casinos and between 1997 and 2005 as an advantage player himself, considers it is not cheating. So that's the expert view. His informal survey, as he put it, of hundreds of people has provided the answer that the general but not universal view is that it is not cheating. I've not found these expressions of opinion to be helpful. Mr. Mills did not count as gamblers. As far as I can tell, Dr. Jacobson's survey was unsystematic. Neither establishes a generally accepted view. So that was the material that the judge had as to, so to speak, the general view. So he wasn't just decided on Mr. Ivey's view. And it may well be in a case like Starglade and Nash that the court feels in a good position to decide whether the way in which an insolvency of a company is conducted by a director is dishonest or not, because the view in Starglade, in a few sentences, was that Mr. Nash didn't like one of the creditors, and so he, I think if I got it right, he engineered the distribution of assets on the liquidation of the company so as to disadvantage that creditor. He didn't put money in his pocket, but he acted to the detriment of the creditor. The judge thought that that was not dishonest. The Court of Appeal took the view the judge had got the analysis wrong, and they could substitute their own view for the judge's view, and did so. And I know my Lord Hughes was a party to that decision, so he will know the case well. So the court in that case felt able to do it. I would respectfully submit it's a very different story to come into a case about a casino environment and start saying, well, this is what the boundaries are between cheating and not cheating. I mean, obviously there'll be some cases which we all agree are obviously cheating, deliberately marking the cards or something. There are some cases which aren't cheating. I think the respondent conceded below that for example, card counting isn't cheating. Because it said, oh, well, that just involves a skill. That will, of course, produce in some circumstances a very advantageous position for the player. And in Punto Banco, for example, if you and you're allowed to, I'll talk about fairness in a minute, you're allowed to card count. The casino doesn't stop you from doing so. In fact, it's sort of...
It's a central part of quite a lot of card games, to card count, isn't it? Bridge is an obvious one, so is cribbage.
But your lordship, the fact is, a lot of casinos reserve the right to expel and do expel card counters.
That's a different point.
Yes.
Yes, that just means that they're not prepared to...
It doesn't mean, I agree, it doesn't mean it's cheating, but what it means is that you certainly can gain an advantage by doing that, and your lordship may say instinctively it obviously isn't cheating.
I mean, if in this case they'd managed to, it would have been physically possible for them to identify the 7th and 8th without getting the croupier to do anything.
Yeah.
Simply by observing the backs of the cards. That would have, I think, I don't know, maybe arguably otherwise, but it would not have been cheating, it seems to me. You're taking advantage of an objective fact and not causing it to happen. The difference between marking a card and observing a mark that's already there is that you've done something
All right.
which has enabled you to get an advantage.
All right.
And unappreciated by the casino. And what's said against you here is that by using the croupier unknowingly to do that, it's equivalent really to marking the card.
Well, that's what's said, but let me answer.
That's why I put it to you, because I want you to answer.
So what we're trying to grapple with here is, so to speak, where do you cross the line? Because if you see the casino making a mess of things because there's security procedures, you can see cards.
That's not this case.
So this is basically making a positive request.
Yes.
Knowing that if the request is complied with, it'll help you, give you an advantage. Knowing that the casino doesn't realise it will give you an advantage, and knowing that if it did, it would say no. So let me fire an actual example at you and ask you the question. In the evidence in the case, told by Mr. Mills, I think the defence expert, anecdotally, there was a case in which the casino loaded the shoe up with unshuffled cards. The reason why this happens is because the casinos buy the cards in, they're meant to be pre-shuffled. So when the new packs of cards are opened, the casino do not shuffle them, they just load them up. So these cards, by mistake, no doubt by the manufacturer, had not been shuffled. Right. So they put the cards in the shoe, and the players realised that the cards were in a sequence and bet accordingly, right?
Yep.
And they bet the whole way through the shoe, it would seem, doing this. The casino didn't notice, and when the casino found out why, the casino said, all right, that's our mistake, you can keep the winnings. Now, let me ask, this is the question. First of all, is it not really the position that in that situation, after the first coup or the first few coups have gone through and the players realise that the cards are unshuffled and they realise the casino does not realise that and they say, I'd like to bet on the next shoe, are they not making a request for the casino to let them play the next hand, knowing that the casino doesn't realise that...
But they haven't done anything. They haven't asked the casino to do anything.
Well, they've asked... Well, all right. Let's say we get...
Completely different from this.
All right, my lord. I may fail on this, but let's imagine they get to the end of the first shoe and the casino hasn't spotted it, all right?
Yeah.
And they then say, well, that was very good. We'd like to play again. The casino says, fine. They say, but we would like to play again with another lot of new cards, please. And the casino says, all right. As opposed to reshuffling these ones, will you load it up again with new cards? And they do it again. Now, on that occasion, in my respectful submission, they have made a positive request to the casino to do something.
Well, because they're assuming the next set of cards are similarly unsharp.
They're hoping that'll be the position. Let's assume they're right. But the point is, and maybe you'll be against me, does that cross a boundary? Does it mean they can sit there, take advantage of the casino's mistake, make repeat requests to play more? Can they, for example, say, well, we'd like to bet a bit more. We've got a ceiling of £5,000. We'd like to make it 10 grand.
I think the fact that there may be grey areas
Yes.
doesn't mean that A, we don't have to decide which side of
Correct.
the line you are in a grey area.
Correct.
B, the fact they're grey areas doesn't mean, and I'm not saying that it is, but doesn't mean that this is in the grey area.
No, I'm obviously, I'm hoping that you'll say it's not a grey area in Mr. Ivey's favour, but at the very least, I'm hoping you'll accept that it is a grey area, and then you have to ask.
There's black and white, and there is grey, and the
Yes.
question ultimately in this case is whether or not you're in the grey area, which side of the line are you?
Yes, well, I think it's a reasonably promising start, and may not be on the grey area debate, that the 4 judges who looked at this have all decided the case on a different basis. That's certainly true. And 3 of them.
And 3 different reasons for doing you down.
I know, but I mean, that doesn't.
They're all different, you say.
That doesn't make it.
They're all right.
Put it another way, if that's black and white, that's a bit of a shocker because, and especially, for example, if the construction of Section 42 I've gone over, if that's black and white, you get 2 judges saying different things about it. That's surprising. I don't think, being fair about it, I don't think that's. I think it's obvious that this is a difficult issue, and the judge didn't find it easy. The judge's analysis, if I may say so, was impeccable in the sense that he rehearsed the evidence absolutely correctly. I think he identifies the issue correctly. But ultimately, and I'm not criticising him because
He basically says this is what happened, it's cheating.
exactly. So he said basically, if it's, I mean, I'd got probably the wrong analogy. If it's got 4 legs and a trunk, it's an elephant. But that's it, so to speak. But
I mean, basically, he said that Mr. Ivey, clever though he is, got the deck fixed.
He managed to. He certainly gained an advantage. The question of whether it's a legitimate advantage or illegitimate.
It's the whole question.
That's the question we're all buzzing around.
Your point is that everything he asked for was done openly. It wasn't like secretly marking a card. He said to the casino, do this, do that.
Yes.
And they did it.
Yes.
So they walked straight into it, but that was their problem.
Well, it was their problem for sort of, if you like, with underlined or with knobs on, because they knew he was a professional gambler, and it went on for a long time. This wasn't a flash in the pan.
No.
I mean, as the judge analysed, he was winning and winning and winning, they had, of course. The fact they could have protected themselves and didn't is obviously not determinative, but the fact is there that all these requests were ones that they had no need to comply with at all. They chose to do so. And I think there's another aspect to this, if I may respectfully submit. There's a reason why they chose to do so. The reason why they chose to do so was because they have the perception that if they humour gamblers, especially high rollers, they will induce them to carry on gambling for longer than they might otherwise do. And because the odds of the game are set the way that they are, unless the gambler finds a way of getting an advantage, they'll lose. And so what they do is they pander to these requests for a reason. It's not just, they're not duped in the sense of being conned into it. What they do is they decide deliberately. In simple terms, what they're saying is, this person is doing this because they think it's going to make a difference. It isn't going to make a difference, but if we humour them into thinking it'll make a difference, they'll sit there hoping that it will. So the Court of Appeal didn't like the cat and mouse analogy, and we haven't revived it in front of this court. We were trying to stick to more rigid legal analysis.
You just did.
Sorry? Right, well, okay, I didn't use the words cat and mouse right anyway. But the point is that there's 2 sides to this. Even if we don't have a cat and mouse, there's 2 sides to this. And that's very important, or at least we say it is a relevant consideration.
Yeah. Was there evidence about casinos taking the view that a few high winners tended to encourage other losers?
No, it wasn't so much that,
Wasn't
and I'll be corrected by Mr. Plymouth. No, the point was Mr. Ivey's evidence certainly was undoubtedly, and I can almost remember it, was that they want to keep me sitting there, keep me happy so I don't go down the road and lose all my money somewhere else. That was his evidence. Because he comes in with £1 million stake, and they're looking at that, and they're thinking, sooner or later, all things being, he's going to lose that. So that's a lot of money. They don't want him losing that elsewhere. So that was certainly his evidence. But
and that's supported by the fact they do indulge his request. Why do they do it? They can't do it because they think it's going to help him win money for them.
Exactly.
They do it because, your point is, they do it because they think it's superstition. And they know superstition makes no difference, but encourage the gambler to go on gambling, and thereby, because the odds are stacked in favour of the casino, to make the casino.
They'll end up making money in the end. And in fact, there was express evidence, again, Mr. Pymott, correct if I'm wrong, but I think it came from one of his own witnesses, Miss Bennett, that in fact the casinos offer high rollers all sorts of benefits and inducement. The Premier League tickets, all sorts of things. So I don't think there's realistically any dispute about that, or ground for dispute. But it goes a little bit further than that, in my submission, because a lot is made by the respondent, and they put in these TV clips, which I ought perhaps talk about now, talk about luck and things. Now, there's a lot of talk about then that Mr. Ivey and Miss Sun induced the belief that he was superstitious. But this is a two-way street, and can I just, at the risk of, I don't know why all this stuff has come in, but there we are, it has, just invite you to look at a couple of features. First of all, if we look at the appeal bundle A108, this is one of the early exchanges. I don't know if the court has actually looked at these clips or synopsis.
At least some of us have, yes.
Yes.
I have.
But you must appreciate that this is a very compressed outtake from many hours of gaming.
Because I assume that's where the pauses occur.
Yeah, exactly. So, and I think the first clip, for example, we can see from the analysis, which is 8 minutes long, and this is it, page A102, contains footage of the first two sessions and the start of the third session. So you're looking at 3 sessions in 8 minutes. But if we look at one of the first mentions of luck, I think it may be the first mention of luck, it's at page A108, right? This is Mr. Ivey when he's come in. This is A108, I have to turn it sideways. He says halfway down the page, what's this deck? High. And this is Mr. Ivey, where's the other deck? The lucky deck. Mr. Bell says, that's the casino employee, the lucky one. This is the lucky one. Mr. Ivey, this is the lucky one. Answer, yeah, I'm sure of it. Now, I just say 2 things about that. You can either just say, well, that's just a lot of casino banter, which is basically what the judge said, and everyone's banning luck about it. Or you can say, no. He's trying to make them believe that he cares about luck. But what are they doing? They're saying, yes, this is a lucky deck. They obviously don't mean that. There isn't such things lucky deck. What they're doing is they're trying to encourage him in his, as they think, belief that luck matters. And so we say that if you're talking about deception, any deception, the answer that should have been given there is, what you mean by lucky? There are no lucky decks. It's a perfectly ordinary deck of cards. You're not getting luck out of it. But they don't say that. This is, we say, symptomatic of the dialogue that was going on. The other thing is to do with deception, because that features in the respondent's case. They say the judge was wrong to find that there was no deception here. They say there was deception. And a couple of things that you must appreciate in my respectful submission before you analyse this is that this compression of the TV clips can be very misleading. Again, I don't know whether the court has had a time to look at part of our skeleton argument below, page A143 onwards, because this is what we used in the Court of Appeal. This is some simple cut and paste from our appeals skeleton.
Okay.
In first instance. But the point is that I won't read all of this for obvious reasons, but if I just draw some things to your attention.
Of course.
If you go to page A145, paragraph 92.
Thank you. Yep.
The first material contact with the claimant began at about 15:30 on 20th of August. Defendant agreed with the claimant's request to be permitted to reuse the same deck of cards if he won. At around 15:39, the claimant asked, what happens if I get lucky and I want to use the same deck? Defendant's Mr. Blockley replied, you can use them again if you want. It appears Messrs. Malone, Blockley and Bell were present at the time. The dealer was Kay Grimshaw. None of these individuals have been called to give evidence. So the people from the first session were not called to give evidence. And we make the points, A146 at 94.1, 94.2. First of all, we say you can't get anything out of the references to luck. And second, none of these people was present at the much later time when the edge sorting began at 9 o'clock on the 20th of August. Right? And then at 97, I'm just darting around this, when he asked for angel cards, Miss Bennett's evidence, this is 97, at the time it was our standard practice to use angel cards during games of baccarat. Angel cards are made up of 8 decks and come pre-shuffled, and then therefore we say the main reason why they agreed to that was because that's their usual practice. And if you look at A147 98.3, this is Miss Bennett's interview after the occasion. She's one of the casino employees interviewed after the event. It appears in the transcript of that interview, Miss Bennett's only concern at the time about the claimant using angel cards was that, quote, we were supposed to be keeping them for LY, and we only had about 26 in the building. Now, this turned out to be a mistake, but basically they were quite pleased that Mr. Ivey was asking to use the angel cards again, because it meant they didn't have to use them up, and they had someone else they needed to use them, and that suited them. They were wrong, as it happens. They had many, many more packs. They didn't know that. But there we are. And then the rotation, I'll come to the details of that. And then you look at the end of R104. These are the employees. This is in the second session. Again, I think I'm writing all people who didn't appear in the third session. This is where they're talking out of Mr. Ivey's presence on the camera, though, about what's going on. And one of them says to the other, I think he must keep around as a good luck charm, I think. Miss Wotton says, well, he's got this thing about Asian dealers, so he's superstitious. And we say that is basically the staff's take on it. He says, because he wants an Asian dealer, he must be superstitious, not because he says that's what's going to suit me, and so on. And so if you look again at 111.4, this is Miss Bennett again. The reason why we had allowed the claimant to reuse the angel cards was we had a major player arriving next morning, Zed Lee, who has 3 tables and goes through the cards like anything. We're supposed to be keeping them for him. And then you get the exchange of paragraph 112, which the judge analysed. I'm going to go to the judgment next, which is at the time when the edge sorting began. And so 112 from our skeleton is the same quote as the judge deals with in his judgment. And I'll go to the judgment next, if I may, and deal with that there. Because our submission is that the judge got this absolutely right and was certainly entitled to take the view that he did. So I want to go to the judgment next, behind divider 11, page A196. And this is dealing, just to put the context, with initially a different request, which is to put the divider towards the back of the shoe, because as the court will know, last cards in the shoe are not played. So casinos typically, I believe these days, put this divider about one deck in from the back, so you only ever get to play 7 packs in an 8-card shoe. What was being asked for was to put the divider in the traditional way, which is 7 cards from the back, and obviously that helps the player in all sorts of ways. If you've edge sorted, it gives you more rounds to play. But if you're card counting, it helps you because it means there are fewer cards unplayed. And so if the distribution of cards throughout the shoe is uneven, and you realise at the back of the shoe there is a big bunching of cards of similar value, you can place bets on egalite, divided equal hands, and the odds are much better than they normally be, because even there's lots of cards of similar value at the end, that's going to be the mathematical consequence. So I'll pick it up, if I may, from 17, because that sets the context. All the games of Punto Banco played by the claimant, Miss Sun, on the 20th and 21st of August were captured on CCTV, mostly with contemporaneous audio recording as well. The moment at which they persuaded the croupier, Cathy Yao, to rotate the cards was at 9 p.m. on the 20th of August. It's been captured on video and the words spoken have been transcribed. Before then, the claimant and Miss Sun had played part of four shoes, the first two plain-backed, the second two angel cards, but note with no asymmetry on the back. The claimant is a high-stakes gambler. He began by his standards modestly. Bets placed on those four shoes ranged from 4,000 to 75,000 per coup. He was losing. At 8:56, he requested a new shoe of cards. A new shoe was produced. The cards were blue angel cards with the rounded pattern which I've described on the back. At 8:57, the claimant asked Jeremy Hillier, the senior croupier overseeing the game, if I win, can I say I want the same cards again? To which Mr. Hillier replied he could, because he was not bending them. I interposed nothing about luck there, just simply you're not touching them. The claimant had in fact avoided touching the cards from either the first or second shoe onwards. The croupier, Cathy Yao, then put the cards face down in blocks on the table to make the cut. She cut the cards so as to exclude about one deck from play. The claimant asked about the cut, why so big? Miss Sun said they don't cut the 7 cards, a reference to the traditional cut of 7 cards in the end. Miss Yao asked if he wanted her to cut 7 cards, to which he replied yes. He wanted to play 90 hands, slightly more than the maximum likely to be possible with an 8-deck shoe with a 7-card cut. Mr. Hillier asked the gaming manager, Louise Bennett, also present in the room, if she could. She must have signified assent off camera because Mr. Hillier said yes, so that's the cutting point. Miss Yao then dealt the first coup, player 1. Miss Sun then asked Miss Yao in Cantonese to do it. In other words, turn the cards over so that the face showed slowly. Miss Yao said yes. Miss Sun then asked her again in Cantonese to turn the cards in a particular and differential way as they were being exposed and before they were put on the pile of used cards. If I say it is good, you turn it this way. Good, yes. No good, a slightly different sounding Miss Yao did not immediately understand what was required. She asked, so you want me to leave it? And that, I think, was said in English, to which Miss Sun replied, change, yeah, change luck. Miss Yao said, what do you mean? Miss Sun gestured how to turn it this way. Miss Yao, what, just open it? Yeah. Miss Sun, signifying good in Cantonese. On that coup, banker won. The claimant then chipped in, yeah, change the luck, that's good. Anything to change the luck if it's okay with me. It is okay with me. Miss Sun reiterated the request in Cantonese. If I say it's not good, you turn it this way. If it's good, turn it this way, okay. To which Miss Yao said, okay. When she turned over the cards of the second coup, Miss Sun said of 4 of them good, 1 of them not good in Cantonese. Miss Yao did as requested, turn the good cards over end to end, the not good cards side by side. In consequence, at the long edge, the not good card was orientated in a different way from the long edge of the good cards. This procedure was followed for each of the next 79 coups dealt from this shoe. The maximum amount staked by the claimant on the coups toward the end of the shoe reached £100,000. Self-evidently, at no time during the play of this shoe did he derive any advantage of the rotation of the cards requested by Miss Sun because that occurred at the end, not the beginning of each coup. At 10:30 p.m, when the shoe was exhausted, the claimant said he'd won with that deck. He said he'd keep it. Mr. Colleen, who'd brought in a new deck of cards, was told by the claimant he didn't want them. He'd won 40,000 with that deck. Mr. Colleen said there'd be no problem. The original deck was reused. The defendant has not been able to calculate retrospectively whether that assertion by the claimant was true. So that is the dialogue which took place. And the judge's findings on this are to be found at 38 and 39, but 39, I'm reading 38 out of complete and scrupulous fairness. 38, Crockfords maintain the claimant practiced deception upon him by pretending to be superstitious. Sorry, it's page A200 in the electronic bundle, when he was not. For example, by making a fuss over Lucky Crockford's hats, which he and his son wore, by asking for lucky cards, and for a Chinese croupier on the ground that he got lucky when playing with Asian women. If this was a ploy, it was succeeded. The Crockford staff believed that he was very superstitious, discussed it amongst themselves, he was not present. In my submission, that's a reference to the bit I showed you at the earlier sessions. The staff were not present when the edge sorting began.
Yep.
A surprising and striking omission from the evidence called by Crockfords is Miss Yao. She's not given evidence. I cannot therefore safely infer what, if anything, she believed to be the situation which she agreed to sort the cards differentially. I cannot safely say precisely what caused her to do that, beyond accepting as I do that she followed house policy in doing whatever a high-rolling punter requested which did not corrupt the game. She said when interviewed about the matter by Mr. Hoskins a few days after the event, she thought the claimant had played fairly. She, I'm satisfied, was not to any extent complicit in what occurred, was wholly ignorant of the potential consequence of turning the cards in the manner that she did. The claimant describes what he and Miss Sun did as legitimate gamesmanship. I'm not satisfied it amounted to deception of such a kind as to vitiate the gaming contract. What they did was to play up to Crockford staff's perception of what influenced his play, superstition. It was by itself on the right side of the line, separating cheating from legitimate gamesmanship. By itself, it was no different in principle from a shrewd and numerate poker player or blackjack player pretending to be a fool. A legitimate technique of playing games which the perception of one player of another may influence his play. His purpose, which succeeded, was no more no less to try and ensure that the casino staff, particularly Miss Yao and her immediate supervisor, Mr. Hillier, did not depart from the usual practice of humouring high-stakes gamblers by acceding to a request which did, in their view, not affect the outcome of the game. But it did. What the claimant and his son did was to persuade Miss Yao to turn some of the cards in a shoe so as to permit them to know what they were, or very likely to be, 7s, 8s or 9s, to do so in circumstances which they knew she did not realise that she'd done that, and if she had, she would immediately have stopped play and sought the advice of her supervisors, who would inevitably put an end to it. So on the issue of deception, he rejected the case that there'd been any material deception, and in my submission he was fully entitled to do so.
Certainly rejected the assertion, which I think had probably been made by the casino, that there was a deception from the beginning in pretending to be superstitious, or rather, if it was a deception, it was within the ambit of perfectly legitimate. But what about is he saying anything there about persuading the croupier to rotate the cards differentially?
Yes, he is, because he's in 39, he's saying exactly that. I cannot safely infer what, if any, she did in the situation when she agreed to sort the cards differentially. He is saying exactly that, my lord.
Yeah, well, is it not a finding that he persuaded her to do it by persuading her, in effect, that it was a harmless request and had nothing to do with the playing of the game?
I don't know, no respect, I don't think that's fair. It didn't persuade her of anything. What he's saying, basically, is he's gone over what happened, he's gone over the can you please rotate it and so forth, and her asking, do you want to do it this way, and they say luck and so forth, and then she starts doing it. Then she does it again for the next 79 coups, with good and bad being told. And what he says is the casino didn't call the witness, and he is unable to conclude that what persuaded her to do it was any talk about luck or anything of that sort, as opposed to just a request, like an eccentric request. Do you mind if you bang the cards down hard before you deal them, or something of that sort? And what he says, and he's entirely right about this, if you go back over the dialogue, she's not, her concern, Miss Yao's concern is we went over it, is basically, what do you want me to do? She's not asking, why do you want me to do it? She's asking, what do you want me to do? And they told her what they wanted to do, and she did it. And what the judge says is, well, they haven't called her as a witness. I don't know what influenced her, but I don't think I can find that what influenced her was an assertion, we only want it done for luck. All she was doing was complying with the request from a high-rolling gambler to turn the cards round in a particular way. So that's the point about the deception, my lord. And I would ask this question rhetorically, at the risk of getting into deep water. I mean, what if, is it really going to make all the difference whether he said, well, luck, change luck, or didn't say change luck? Is it going to say, well, that turns it into cheating, and if he hadn't said that, it isn't? I mean, my case is much simpler, and really, I think picking up something Lord Newberger put to me, and certainly how he's understood the thrust of our submissions, if you make a series of open requests of the casino, and they choose to comply with them, and it happens to be advantageous to you because of a defect in their procedures. They're the ones who use the cards that have asymmetrical patterns. They're the ones who agree to reuse them. They're the ones who don't. To defeat this technique, all that is needed is to turn one part of the deck differently from the rest. That's all that's needed, because that ruins the entire edge sorting, because when you put them in the shuffling machine, they get shuffled. You've got no idea when you're looking at the leading edge whether it's a good or a bad card. There are lots of other things they could have done. They could have put a cover over the front of the shoe, or not done any rotating at all. They could have said, no, we're not having any of this rotating lark. But they didn't. What they said is, sure, we'll rotate, we'll do all the rest of it.
If I was playing bridge with you,
Yeah.
and I saw that actually if we moved the chairs around a bit, you'd have a mirror behind you, and you were stupid enough not to notice.
Yeah.
And I said, can we move round slightly? And we moved, and I could see your cards in the mirror.
Well, that would do.
Would I be cheating?
Yeah, I would say I would say it would, but
Yes, right. So what's the difference between that and this case?
because this is all to do with asking them to use their ordinary equipment in a particular way. You're not asking to show you.
I'm asking you to move your chair in an ordinary way and playing bridge.
That's done it's done for an ulterior purpose, and it's not to do with your.
But that's what your equipment.
No. And I've given the answer I have. I think
Yes,
it would
but
be.
what is the difference between my example of the bridge? There may well be one, but I'm just because does seem to me the bridge case is a cheat.
Well, what if you? I mean,
What's the difference?
Well, let me put it another way. What if you ask the casino? I wasn't going to do this. What do you ask? Would you mind if you actually turn all the cards face up before I bet? And they say yes. So you could see them. I mean, then you ask them to do something which gives you an advantage.
But that is obvious. That's not an oversight. In the mirror case, you don't know about the mirror. In the bridge case, example I've given. In this case, they don't appreciate what they're doing.
Well, the way I'd look at it is
What's the difference?
no. I think it's to do with the mirror probably, because what I'd say is this: it would be, I would say, dishonest to
Well,
manipulate.
never mind about dishonesty. It'd be cheating.
Okay, well, all right, cheating. Well, I'm prepared to go first. To set up a mirror behind someone's
No, the mirror's
castle.
already there.
I know, but it makes no difference. I'm giving the best answer I can, my lord. It makes no if it's wrong to plant a mirror behind someone's hand and look at it, it can't be right to not physically plant the mirror, but seeing a mirror's there, manipulate them into a position where you can use the mirror to see their hand. It's the same thing.
Well, that's like saying that you supply the cards to the casino. In this case, they haven't supplied the cards to the casino. I mean,
Well, my lord, I don't think it is, because they have a whole system in which they can. This was an unusual request. I think if you
asking somebody to move their chair may not be a particular. I don't play bridge.
well, it would depends who you play bridge with. I think some of us might be more suspicious than others, but I think also there's a difference. There's a difference, or maybe a difference anyway, between what is acceptable conduct in a social game-playing environment and what is acceptable in a casino environment, because my personal stance or suggestion would be that most people playing bridge, for example, socially amongst friends, would be very careful, for example, not to look at people's cards, and if somebody was unwittingly showing you the cards, to point it out to them and not take advantage of it. I wouldn't accept that would necessarily be the position if you were playing a card game in a casino, and if you saw that the dealer was careless in the way they dealt the cards and enabled you to get a glimpse of them, whether you would be bound to point that out to avoid being a cheat. That's what I'd say. There are differences there, and certainly if you think about other environments when you're playing games competitively or something, if you're playing social tennis, I think, and you hit a shot which you think is out and your opponent doesn't spot it, I think any honourable person would say, I think that was out. But if you're playing a competitive match, and apart from the fact if you're playing at Wimbledon, you might trust the umpire and the Hawkeye and things, I don't think you necessarily have quite the same obligation. I mean, the starting point in that situation is it's for the recipient to call the ball. And so it's up to them to say whether it's out or not. It's not for the server to say, my serve was in or out, it's the recipient to say. But if you think it was out in a social game, I think if you were doing the honourable thing, you would say so. You wouldn't steal a march on a friend. But I don't think you feel the same.
A highly competitive international bridge, where again I only know what I read about, where people sometimes get up to things they shouldn't get up to. It still would be cheating if you were.
Oh, 100%. Because but there are, and that was all the recent Shapiro stuff all those years ago. Of course, that's right. But if you start asking other questions like, is it permissible to use information that goes beyond the strict face value of the cards and bidding patterns, for example. Again, I was thinking about this on the way in. If you're playing bridge socially, and you're bidding, you should also ask about bridge, you're bidding in bridge, and you know that one of your opponents has a propensity to be a wild bidder or a cautious bidder, are you to exclude that from your mind and say, oh, well, that person usually plays low or is too extravagant? You don't, and nor can you. But what if you goad them into it? What if you make a bid which you think is likely to provoke them into a particular response, and you feed that information? Is that cheating? I mean, it's you may call it brinkmanship, sportsmanship, whatever. But if you manage to provoke them into giving away something, I would say that isn't cheating.
Yes, I see.
Some people may not. Some people take it in good part and think that you've done a good job. Some people may not want to play with you again. I just don't know. But I'd hesitate to say that was cheating. So, my lord, the best answer I can give you on your mirror example is I think that it would be wrong to set up a mirror behind somebody to look at their cards, and it's no different to get them to move around so that you can see through a mirror that's already there. But it's quite different if you're in a casino you know that they are going to comply with the request you make because they think it'll make no difference and they'll just make lots of money out of you. As you'll sit there and lose, and you actually realise it will make a difference. I would say there is nothing wrong, and it certainly isn't cheating, in making the requests which anybody else could make. Anybody who's playing the game could see the cards, the backs of the cards, the defects. Anybody could make the requests. It's information open to all. It's not been obtained covertly by getting to move the chair around or put a mirror behind them. And if they want to comply, they will comply, and if they don't, they don't. And that's that they've got a lot of procedures for protecting themselves against this, the simplest one of which is not to agree to the request in the first place.
We were on specifically the question of whether there was a deception.
Yes, we were.
My short note to myself says this, and I just want to know whether I've got it right. It wasn't a deception by a pretense that it was a harmless, irrelevant request. It was simply an eccentric request which involved no deception.
Yes.
Is that right?
Yeah, the judge was right that he not to find and that he could not find that the dealer, Cathy Yao, was deceived into
thinking it was a harmless request.
Exactly. She may well have thought it was harmless, that's
clearly
true,
did.
but that's not the same thing as being deceived into it.
I see.
Yeah,
got it.
And there were lots of other requests made that no doubt would have been harmless.
You say, in a sense, it was the bite a bit. It was the
Absolutely.
casino indulging somebody for their superstition, encouraging them to think that the superstition would get the money, knowing perfectly well it wouldn't. And actually, it was going to do exactly what the casino wanted them to believe it was going to do.
Absolutely. What they're doing is they're sitting there, they're laughing up their sleeve because they're thinking, this chap has got all his weird ways, he wants the cards rotated, he wants to do this, that and the other. He's a mug because we're going to make money. And he's sitting there thinking, they're the mugs. They think that all these requests aren't going to get me anywhere. They are going to get me somewhere. If it all works, of course, which isn't guaranteed, and that's their lookout. And that's why he genuinely believed, and I would say if you have to resort to an ordinary standard, the ordinary reasonable person would believe. And I'll tell you this, which may be a false or an ambitious claim, if this was a Section 42 prosecution in front of a jury, I would rather have the defence brief than the prosecution brief, because I don't think a jury would regard this as cheating, and that's the best test of what is the right measure. That's what I would say. I think they'd say exactly what your lordship said, no doubt not in exact words. It's the bite a bit. Exactly right. That's what I would respectfully submit.
They might reach that conclusion whether or not they thought it was cheating. That's what juries are for.
Yeah, absolutely. Well, I suppose in one sense in one sense it is my lady, yes, and in one sense it is a jury question actually.
That's the whole point about juries.
No, I think it isn't a jury question in the sense that my lady meant it. She was saying they might say, even if he's...
Oh, I see. You mean they might think, well, he can keep the money, even we think
Exactly.
it was, yes.
That's what
They were fair game.
And that is not a way a judge can deal with a jury question.
No, the judge, no, seriously, the fair game idea does feed into the concept
No,
of
of course it does.
If it's fair game.
Those of us who would have liked the defence brief in that hypothetical
Yes.
prosecution would have hoped, would they not, to get home on the fair game.
Yeah, absolutely. Well, that's
Not on the absence of cheating, on fair game.
yes. All right. But I don't know. I don't. There's a trap in there, my lord. There's a big difference between the two. Is there a difference between the two? If it's fair game, can it be cheating if it's fair game?
Serve them right.
Yes, sir.
Yes. Well,
Others could interpret your submission as being you'd rather be addressing this case before a jury than before us.
Well, I've only had the privilege of addressing the highest court in the land as a jury once, and that was in the Bruce Grobbelaar libel action, where they had to fix the damages, and I actually said so. I said, "You're now going to get a jury speech." I gave them a jury speech. They reduced damages from £85,000 to £1, so I regard it as a relative success. But anyway, my lords, my lady, just seeing if there's anything else really that's got an eye on the time as well.
I've asked you quite a few questions. If you want a moment to look and check if you've got anything else to say, don't worry, that's fine.
Well, obviously I don't want to repeat all the things that are in the written submissions. Yes, I think I ought to say something about the Court of Appeal judgments. That's quite an important omission for what I've said so far. Well, as we all know, they all took a very different approach, but essentially, Lady Justice Arden, in our submission, really subscribed to the defendant's construction of Section 42, because she approached it, as we know, through Section 42, and she really subscribed to the fact that an interference was all that was needed to amount to cheating under the section, and that there had indeed been such an interference. And one can pick it up most clearly if one goes to A180 of the electronic bundle. In her conclusions,
Yes.
she says the meaning of cheating, paragraph 99, so sorry, common ground is implied term in the party's contract not to cheat. The meaning of cheating for this purpose is to be determined according to Section 42 of the 2005 Act. My judgment, this section provides a party may cheat within the meaning of this section without dishonesty or intention to deceive. Depending on the circumstances, it may be enough he simply interferes with the process of the game. That on that basis, the fact he didn't regard himself as cheating is not determinative. There's no doubt the actions interfered. It's for the court to determine whether interference was such a quality as to constitute cheating. In my judgment, it had that quality, the reasons given above, which reflect those by the judge. And I think in short form, those reasons were that it made a substantial difference to the outcome, and obviously one that I accept that the casino didn't realise.
Basically, she adopts what the judge says in 49, 50 and 51 of his judgment.
Yes,
we looked at.
but looked at through with different
Slightly
spectacles,
different eyes, yes.
spectacles. Lord Justice Tomlinson dealt with it on the civil law.
Yes.
But with my respectful submission, what he did was not permissible at all, because the way in which he decided that there'd been cheating here was he decided that there'd been a deception, and you can see this particularly from 112 of his judgment, page A183, in my of the bundle. My view, the inference is simply escapable. Mr. Ivey set out to deceive, because I think he accepted his evidence, prepared to accept in respectful disagreement with Arden, LJ, that Mr. Ivey did not go beyond the steps mentioned in his description of what he said in advantage played entitled to. Nevertheless, in my view, he did far, far more than simply play up to Crockford's staff's perception of what influences play superstition. See Judgment 40. Mr. Ivey and his accomplice created that impression. He admitted his remarks about luck and superstition were designed to create an air of superstition around our play. Having created an air of superstition, he then used it to persuade the staff to do what would not otherwise have been done, and would certainly not have done if they'd appreciated the purpose. The staff were deceived. as to his reason for wanting the cards turned. This is, in my submission, a conclusion he's reached by compressing all these CCTV events as if they all happened at once, which is a fallacy and quite wrong, and in my submission not appropriate for this court to do either. You have not got all the evidence in the case. You haven't even got in front of you, as the Court of Appeal had, I think, transcripts of the hearing below and the witness statements and so forth. So to say that it is right to reverse a judge's finding of no deception in this way on this basis in my submission is wrong. And then he picks up the point that when he was told that the cards would be changed, he tried to carry out his deception by asked him to be rotated in a random fashion, and when subsequently challenged, he didn't explain what he'd done. He just said he hadn't touched the cards. Those are all fantastic forensic points, but the judge heard them all. They're all totally consistent with Mr. Ivey having perpetrated an entirely legitimate advantage play technique, and B, perpetrating no deception, but C, not wanting the casino to cotton on to what he'd done in the hope that he would be able to do it again. And of course he's going to not want them to see what he's done. He's not going to come out with it because he thinks it's legitimate, but he obviously realises if they know about it, they're not going to allow him to do it, or other casinos won't. And incidentally, this world obviously is not a little microcosm, or it is a microcosm, but it's not in boxes. They circulate information amongst themselves, the casinos. And then he says in 113, in my view, most right-minded people regard what was done by Mr. Ivey and Mr. Sun as cheating. I'm surprised Mr. Ivey did not so regard it, but his own view of his conduct is not in this context determinative. This was a case of physical interference with the cards brought about in a consciously deceptive manner. I'm quite as satisfied this was conduct which falls in the ordinary natural meaning of the word cheating. I find support for that view, even if it's not uniform, in the various dictionary definitions which we've taken, which are summarised by Lady Justice Arden in her judgment 36. So he prefers the concise Oxford English Dictionary definition, it would seem, to the Oxford English Dictionary as being what he says ordinary people would mean by cheating. And he says nothing in the authorities to conclude that conclusion. And then he says this, in my judgment, I read from 113, cheating as a concept in ordinary parlance and thus in common law is as much encapsulated by a notion of fairness in order to gain advantage or by the notion of practicing a deceit as it is by conduct which is by ordinary standards dishonest. And then he says that the Theft Act talks about dishonest deceptions. A finding that Mr. Ivey here practiced deception is not inconsistent with the judge's finding he'd not behaved dishonestly. Well, in my submission, first of all, it's interesting to notice, although he alludes to fairness, cheating being as much encapsulated by the notion of unfairness in order to gain advantage, as well as to deceit, in fact, he doesn't find it on the basis of unfairness. He finds it on the basis of deceit. He finds it on the basis of a deceit which he says is not incompatible with a finding of no dishonesty. So it's an honest deceit. And he finds it where the judge didn't find any. So number one, he was not entitled, in my respect, submission, to say the judge got this wrong and reverse the judge on it. Number two, the concept of an honest deception is a nonsense, and certainly in this context it's a nonsense. And number three, as I pointed out, he certainly didn't decide it on an unfairness basis because he decided on a deception basis. And I think lastly, in seeing the time, which is absolutely on the minute at 12:30, I won't go over Lady Justice Sharp's judgment. We put it in our case. We say, in fact, she got it right, that there's only one test here. This is a regulated environment, and that's a relevant consideration. She found that it had to be...
No. Yes, carry on.
That's all right. Thought has some wider support here, my lord, which is always welcome, even if it comes a bit late. But there we are. Anyway,
yes,
so,
they might be able to oppose you, Mr.
well, I don't know.
Anyway, carry on.
I'm tempted to ask them the key question, but I'm not going to do it. Anyway, so my lords, my lady, we say that Lady Justice Sharp got it right. I mean, she was right. And Lady Justice Arden, incidentally, as well, to approach this whole thing on the basis that this is not just a contract in a vacuum. It's in a regulated environment, and the legislature's approach to cheating is informative. We just say simply that Lady Arden got the approach wrong and Lady Justice Sharp got it right.
Thank you very much.
Now, my lords and my lady, I don't know if there's anything else that I can usefully add.
Thank you very much, Mr. Spence.
We'll read 2 hours, and that's it.
We started late, and by my computer it's 12:30, so you've done well. Thank you very much.
Computer's a bit slow.
Like its watcher. Mr. Mallon. Thank you very much. Mr. Beaumont.
My lords, my lady, may I start, as did my friend, with just a few points in the facts that would explain and provide the context for the submissions that I'm going to make on the law. Starting first with the game of Baccarat and the particular version of it, Punta Banco, which is in issue here. This is a game of pure chance. It's not skill. There's no mixed skill or chance and chance. It's pure chance. The judge's explanation, which we needn't look up for these purposes, but for the court's note, it's paragraphs 4 to 7. He explains what the game is all about. And the two features that he shows are these, which are worth observing. The first is that the dealer deals the cards in a sequence from which no deviation is permitted. And the second is that the punter bets before any card is dealt. So in other words, after the punter has made his bets, the cards are then dealt in a prearranged, predetermined fashion according to the rules of Baccarat. Now, my friend's expert, Dr. Jacobson, had a vivid phrase for this. He said that this kind of game was a brain-dead game, meaning that there's nothing to do once you've made your bet. You just watch the cards play out. That was a point that was picked up by Lord Justice Tomlinson at paragraph 107 of his judgment. Now, it's worth thinking what the consequences of that are. The first is that the essence of the game is that there be a random distribution of cards and that the punter does not have any information about that distribution before he places his bet. The second consequence is that the game is not one played against anybody. It's not played against another player, and it's not played against the bank. The punter simply bets and watches how the cards play out. Now, from time to time in these proceedings, the phrase cat and mouse, or as it was put to one of my witnesses, dog eat dog, arises. These various animal references about what might be going on in a casino.
Well, we've had elephants, cats,
Yes,
dogs,
indeed.
and mice so far. Yes.
Well, to avoid the menagerie, all we would say is that so far as the rules of Baccarat are concerned, this is not a dynamic game. This is not a sort of game in which you can obtain advantage by gamesmanship. You just make your bet and then you watch the cards play out. So there's no adversarial element to it. The third consequence of the sort of game that it is that the probabilities of all the different outcomes can be worked out. They are fixed because of the fixed rules of the game. And that means that a mathematical advantage can be worked out as to who is likely to win or lose. And we know what that is. It's in favour, hardly surprisingly, it's in favour of the casino, the so-called house edge, which the judge explained in paragraph 7 of his judgment. 1.24% on player bets, 1.06% on banker bets. The difference being because there are differences in the rules about whether banker or punter gets extra cards. And the payout is slightly different on banker bets and punter bets. So we did in fact have expert statisticians who gave evidence before the court, and they'd agreed, in fact, slightly different percentages, but the judge chose Dr. Jacobson's, and I'm not suggesting he was wrong to do so, but no doubt mathematicians can come to slightly different conclusions. But the important point is that over time, the bank will win. The bank is not attempting to win every round, clearly, or to win against every punter, but the business model is based on the mathematical computation, which is that this is a game which over time will allow the casino to make money. And as a further point here, so that there's nothing untoward in the bank's conduct in this respect, it is a requirement of the Gambling Commission that the house edge is published in the casino so that any punter can consult it if they're interested. Now that is the game and the consequences of the game. What happened here, what Mr. Ivey set out to do, and what the judge found he'd managed to achieve, was to obtain information about the lie of the cards before they were dealt. Specifically, whether they were the strong cards, 7, 8, and 9. And the point of doing that was to increase his chances of winning, which he achieved very dramatically. It's instead of the 1% or so against him, it becomes up to 6.5% in his favour. This is the judge at paragraphs 12 and 13. And the effect on his winnings is then explained by the judge in paragraph 27 from a fairly low base, a fairly low success rate on his betting in the first 5 shoes. In the 5th shoe, he identifies the asymmetric cards. So the 5th shoe is played out with the cards being turned. And then from the 6th shoe onwards, yes, he starts betting first at a hugely greater rate of success. And secondly, he starts increasing the stakes for which he's betting. And the total overall is something in the order of £100 million that he'd staked, from which he purports to win 7.7. So he's done slightly better than the maths would suggest.
Understand.
Now, he did this, the judge said, by edge sorting. That is, by directing the cards, physically orientated, differentially, so that he could distinguish the strong cards from the weak when they next appeared at the front of the shoe. And crucially, before he placed his bet. For the practice to succeed in its aims, it was essential that the dealer and the inspector should not know or suspect the purpose for which the sorting of the cards was intended to achieve. Just to be clear, the dealer is, in this case, Ms. Yao. She's the woman at the table dealing the cards. But there is always an inspector overseeing probably more than one table, but in the room and watching play happening. So there is a separate person there who is also checking at the time it's taking place that the play is fair and proper. And then there's yet another level of supervision above that, who in this case was Ms. Bennett, who was for most of the time the person with a more general supervisory role.
If he'd worked out, without asking or saying anything, it may have been impossible on the way they would otherwise have dealt with the packs, but if he'd worked out that, for instance, he'd noticed that the 7, 8s and 9s had a slightly different configuration on the back. He had no influence over it, but he just worked it out and bet accordingly. Would that be cheating?
We say probably not cheating,
so
because he's just looking.
He's got to have done something.
He's done something.
Yeah, thank you.
Take the example my friend mentioned. It was actually given by Mr. Hoskins, who's the as well, compliance officer at the time. Mr. Hoskins says he recalls an occasion where inadvertently the bank had been using unshuffled cards, and the punters saw that it was unshuffled, but the dealer didn't, or if they didn't think what the significance of that was, and the shoe was played out in full, and at the end of it a review took place, but the casino said, well, we played with these cards, that's our problem. And that's really the same point I think your Lordship is putting to me.
It is. A better example, it is indeed. The point.
If the punter doesn't do anything to alter the orientation or the outcome of the cards, of the deal of the cards, then there's not a problem.
Yes, I mean, that as a generalisation, that probably wouldn't do, because if somebody else, wholly associated with him had done something to fiddle the cards so that there was, and he was then told about it.
Yes.
That would be cheating, you would say, even though he had nothing to do with it, but somebody had done something naughty and he'd become, as it were, party to it.
That's right. And I mean, jumping ahead to section 42, that is the significance of the word interference.
Right.
That's why it's a very general word, but it's actually crucial.
Well, are we now dealing with the second or third? Are we dealing with the implied term or section 42?
I will be dealing with implied term first. I'm just making my general comments first about the way in which the scam took place and what Mr. Ivey achieved.
Because with the common law implied term, I have a slight difficulty with section 42 having anything to do with it.
Yes, and we do too. So I will be making that submission.
Thank you.
What the judge found, which is worth going to in his judgment at paragraph 41. Your lordships and your ladyship have just been looking at it in my friend's submissions. This is from 39 to 41. His conclusions about, in effect, the deceptive quality, or at least the secretive quality of what he was doing. He says in 39 that he didn't have evidence from Miss Yao, so if you're not sure what her position would be, but he accepted that she was doing, what was she doing? She followed house policy, this is 39, halfway down, followed house policy in doing whatever a high-rolling punter requested, which did not corrupt the game. That's what the judge was finding. She had no reason to think that he was corrupting the game. He then goes through his views about legitimate gamesmanship. We're bound to say in 40, what legitimate gamesmanship can possibly arise in the game of baccarat? There is no gamesmanship in baccarat. You bet and then you wait and see how the cards play out. So quite what the judge had in mind in paragraph 40 is not entirely clear. What he did say is, I am not satisfied that it amounted to deception, not generally, but to deception of such a kind as to vitiate the gaming contract. So that may be all he had in mind, was whether or not what they were doing itself vitiated the gaming contract. But then in 41, he clearly is finding that there was some kind of deception involved, because he says that his purpose, which succeeded, was no more and no less than to try to ensure that the casino staff, and in particular Miss Yao and her immediate supervisor, Mr. Hillier, did not depart from the usual practice of humouring high-stakes gamblers by acceding to a request which did, in their view, not affect the outcome of the game. But it did. What the claimant and Miss Sun did was to persuade Miss Yao to turn some of the cards in a shoe so as to permit them to know what they were or were very likely to be, 7, 8s or 9s, and this is a crucial bit, to do so in circumstances in which they knew that she did not realise that she had done so, and that if she had, she would immediately have stopped play and sought the advice of her supervisors, who would inevitably have put an end to it. Now, this is not entirely innocent activity, therefore. This is not just saying, oh, look at me, I like the Crockford hats, and I'm a bit of a lucky chap. And the sort of remarks that my friend made in his submissions about the innocence of this kind of conduct. This conduct was deliberately designed to throw the casino staff off the scent and to make sure that they didn't realise what was really going on. And that is a finding of the judge, even though he did not go so far as to make a full finding about what Miss Yao would have regarded as the effect of what she was being asked to do. So instead of the brain-dead game of pure chance, which is what is promised by the casino, effectively, what is offered by the casino, on a random distribution of cards, Mr. Ivey was playing with the substantial advantage of knowing the value or likely value of the first card to be dealt, knowing the consequences for himself of that advantage being taken, and knowing, because this is what the judge says in 41, knowing that the staff had not realised that he'd done that to improve his chances for succeeding. Now that was the judge's finding. When it comes to the Court of Appeal, there's a slightly different approach, but the essential findings of the judge are not disturbed by any of the judges in the Court of Appeal. Lord Justice Tomlinson essentially accepted the judge's conclusions, but adding that there was a further inference that can be drawn of deception. Lady Justice Arden accepted the judge's conclusions, but using the test of interference in Section 42, and in her case avoiding any issue of dishonesty, which she thought didn't arise. And in Lady Justice Sharp's case, she didn't really comment on the judge's conclusions. Her point was that it's all about Section 42. 42 requires dishonesty. I don't need to go back to the judge's conclusions on what he did find, because there was no conclusion that I can see of gauche dishonesty. So her ladyship didn't seek to set aside anything that Mr. Justice Mitting had held. So how do things lie now on the legal issues, if I could move on to the legal issues? Permission to appeal has been granted for the primary issues, Section 42, being the issue of public importance. But our submissions in answer are threefold. One is, and the primary submission is, that we never get to Section 42 because we should succeed on the implied term argument.
I understand that.
The second is that, in any case, when you look at Section 42, dishonesty in the criminal sense is not a feature of that criminal offence. And thirdly, we say, even if it were, on the judge's findings and on the inferences you can draw from the judge's findings, then Mr. Ivey was indeed dishonest, or at least cannot claim not to have been dishonest in a Section 42 sense, if that is the meaning of Section 42. So let me turn first to the implied term. As your Lordships and your Ladyship have seen, this was an admitted term of the contract, and nothing that my friend said means he's rowing back from that admission. And we submit that that is indeed a perfectly obvious form of implied term in a case like this. You do not expect, when you go into a casino, that the casino will start trying to do better than the house edge. And in the same vein, the casino is entitled to expect that you, the punter, will not be trying to subvert the game that is being played. That is, in particular, with a physical alteration to the means by which the game is being played. So in those circumstances, the question arises, and the question really for the court is simply, is that implied term breached? Now that's simply a factual inquiry for the judge. What is to be considered is not going to be the subject of any earlier authority. The reason is that until 2005, gaming contracts of this sort weren't allowed to exist. They were illegal. So one can't look at any deeper authority about contracts of this kind. And secondly, as is rather illustrated by this case, one can always expect that there will be new forms of trying to gain an advantage, to put it neutrally, over the casino, which will then have to be subjected to analysis by the court to see whether or not it's cheating. But the implied term that's been admitted is not that it's just a matter of cheating. It's cheating or otherwise acting so as to defeat the essential premise of the game. And in a game like Baccarat, that second part of it is very important, because the essential premise of the game, as we've pleaded, paragraph 11 of our defence, is that it's what Dr. Jacobson described as the brain-dead game. It's not a game in which you can interfere. It's not a game in which you're supposed to work with anything other than a random distribution of cards and no knowledge, no prior knowledge of the value of the card before you place your bet. So if you do something to subvert that position, to gain some extra knowledge, and to increase your chances of winning.
Does it make any difference if it's a brain-dead game? I mean, if you have a game where people are known to be able to count the cards, and therefore it isn't entirely brain-dead, and and the exercise which the appellant indulged in this case was carried out there, your arguments would, and Mr. Spearman's arguments would be the same, wouldn't they?
No doubt, no doubt.
Why
I think
does it matter
that
that
the point I would make is that this is a particularly stark example of a game which should be just played out simply without that kind of advantage. And the essential premise of the game is being subverted if in fact you do something to create the condition that allows you to have knowledge of the first card as it comes out of the shoe.
Thank you.
Note, of course, that the position here was not simply that Mr. Ivey found a way to improve his own, to improve the odds in his favour, but to reverse the odds. That's the key to it. He wasn't just limiting the damage, as it were. He was now making it likely that he was going to win. He established effectively a new set of mathematical probabilities which were entirely in his favour. So the essence of the judge's reasoning we've seen is in paragraph 50, which is using the dealer as his innocent agent to turn the stronger cards differentially so that he could recognise them when they next appeared at the front of the shoe, and doing so secretively in the knowledge that if the casino realised what he was doing, he would be stopped. Now, the question that's arisen, and my friend has suggested arises here, is whether or not there's any dishonesty as a necessary ingredient of the implied term. And if so, our question that we would ask was, are you saying that that is in the criminal sense or in the civil sense? And Lady Justice Sharp has found that the implied term is an implied term not to breach section 42, which means that there is dishonesty, her ladyship found, in the implied term as a significant element, and indeed that that element is one of criminal dishonesty. Now, the number of points I'd like to make about that. The first is a narrow one, which Lord Justice Tomlinson made at paragraph 105 of his judgment. He just pointed out that the context of the concept, the practice of cheating, has a much longer history than section 42 and must have a meaning other than what is defined in section 42. So if you say in your contract, you will not cheat, you are bringing into play rather longer considerations than a narrow statutory definition. And one might add that the concept of cheating would be applicable and would be justiciable even if there were no section 42, or if section 42 were altered to cover some other kind of conduct. So there's no reason why one should look to section 42 to determine what is the ambit of or the content of the implied term not to cheat or defeat the essential premise of the game. more generally, the aim of criminal law is, of course, completely different from the aim of civil law. Criminal law is about public sanction for wrongdoing, civil law about private rights. In this case, whether or not the casino has to pay Mr. Ivey £7.7 million. These are quite different contexts and objectives in which to be considering what are the features of cheating which you should be bearing in mind. Now, my lords, my lady, I'm going to go on to some citation of authority. I don't know if now is a
I think it
convenient
would be.
moment. Or...
Let's resume again at 2 o'clock.
Very good.
Thank you very much, Mr. Pymont. 2 o'clock. Court's now adjourned.